useful for the courts. Judgments online. Judgments usually get highly delayed for being submitted to the parties. Usually, the hard copies are being delivered with high delay for the parties, making available online all the judgments of higher courts such as high courts and supreme courts, and maintenance of a proper database for these judgments will provide lawyers and judges with all precedents and law accessible at their fingertips, and it will reduce the chances of inconsistent and conflicting decisions, which will in turn bring more certainty in decisions and high credibility of the judicial system. It will also reduce multiplicity of proceedings due to conflicting judgments, pendency of many undesirable appeals, and denial of justice due to delay. Preservation of court records. Traditional system of filing petitions in the court are in hard copy, and preservation of the same require large amount of space. Indeed, the high space consuming process in court system would be preserving court records. Making soft copies of the judgments would be highly space saving. The whole of files would be reduced to a small box called the hard disk. Furthermore, retrieving the data from the huge collection of files would be highly troublesome, since the process would take a lot of time and manual labor. There are high probabilities of not getting the file also. These troubles could be avoided with the computerization of the system. Computerization also facilitates controlled destruction of the documents by eliminating the unwanted documents and preserving the main and wanted documents. Video conferencing. Video conferencing is one of the latest tools used in the corporate world for the past few years, tend to be a part of the netizens. This is called as the real-time two-way transmissions of digitalized video images between two or more locations. Video conferencing is relatively simple solution to facilitating people's appearance in court. Video conferencing is the best solution that works to everyone's convenience. It will save millions of dollars in transportation of the under trials at courts, human working hours, and thereby increase the productivity and prosperity of the nations, and finally the prosperity of the humanity all over the world. Electronic trials. This is not a utopian idea in this digital world. At least in some countries, petty offences such as the motor vehicle cases are completely managed by the electronic trial method. But at present, this model cannot be adopted to other cases because judgment should not be made by a person using his judgment should be made by a person using his rationality by analyzing the facts and circumstances coupled with the humanitarian concerns. A judge cannot be replaced by a robot. Laptops and Wi-Fi in courtrooms. As the lifestyle improves, the number of legislations increases, complexities of the case also increases. The mere updating of the courts and equipping the judges or court staffs are not enough. For the court officers, that is advocates, the use of laptops in the Wi-Fi enabled courtrooms will certainly improve the skill of the lawyer and the accuracy of citations of cases and reference to any act or rules. The Indian experience. India, as the leading software hub of the modern world, is having an information communication technology friendly approach and successively started to implement information communication technology methods to the justice administrative system. Ever since computerization started in 1990 with the help of National Informatics Center, many applications have been computerized which have direct and indirect impact on litigants. Now Supreme Court and all 22 High Courts and its branches have been computerized, and the following facilities directly benefit the public. Lobbies. List of information business system is about scheduling of cases to be heard by the courts on the following day. It enabled the registries of Supreme Court and High Courts in eliminating manual process of cause list generation and thereby eliminating any manipulation by vested interests. These databases contain details of fresh, disposed and pending cases. Filing under computerization. In the Supreme Court of India and all High Courts, fresh cases are filed only before the computerized filing centers. Time limitation is checked automatically. Courtnic. This is about providing Supreme Court's pending case status information to litigants and advocates. This is available in High Courts and some district headquarters since 1993. Judice. Judice means Judgment Information System, consisting of complete test of all reported judgment of Supreme Court of India from 1950 to 1998. Judgment from 1999 is available on internet. Supreme Court's pending cases on IVR. Interested litigants and advocates can find out the status of their cases pending in Supreme Court on telephone by making use of interactive voice response system free of charge. Cost lists on internet. Cost lists are scheduling of cases to be heard by the courts on the following day. The cost lists of the Supreme Court and High Courts are published on the internet. Hence, the advocates or anyone interested can generate a cost list of his own from the data, a court-wise, judge-wise, or lawyer-wise cost list. E-filing. Electronic filing is started in the Supreme Court and some High Courts in an experimental basis. E-kiosks. Many of the High Courts started e-kiosks to provide information on cases that in that High Courts through a touch screen computer, and the public can avail the status of the pending cases as well as information about disposed cases with the touch of a screen. Video conferencing. The trend is positive in India. In early April 2003, the Supreme Court permitted trial judges to record evidence from witnesses living abroad via video conferencing. Within a week, a court in Mysore conducted India's first long-distance case involving a copyright violation against Los Angeles-based 20th Century Fox. In Basavaraj versus State of Karnataka, the majority held that Section 313 of CRPC had to be considered in the light of the revolutionary changes in technology of communication and transmission and the marked improvement in the facilities of legal aid in the country. It was held that it was not necessary that in all cases the accused must answer personally by making his presence in the court. In State of Maharashtra versus Dr. Praful B. Desai, the Supreme Court observed the evidence can be both oral and documentary, and electronic records can be produced as evidence. This means that evidence, even in criminal matters, can also by way of electronic records. This would be include video conferencing. Video conferencing is an advancement in science and technology which permits one to see, hear and talk with someone far away with the same facility and is as if he is present before you, that is in your presence. Thus it is clear that so long as the accused or his pleader are present when evidence is recorded by video conferencing, that evidence is recorded in the presence of the accused and would thus fully meet the requirement of Section 273 of the CRPC. Recording of such evidence would be as per procedure established by law. In the case of Sakshi versus Union of India, holding trial of sex abuse or rape, recording of evidence by way of video conferencing vis-a-vis Section 273 Criminal Procedure Code is permissible. All the above judgments show the positive interest of the judiciary in implementing information and communication technology in the courts. Use of laptops and Wi-Fi. The courts in India do not allow bringing laptops to court halls. Wi-Fi is not open to the lawyers or to the general public. The uses of cell phones are also prohibited due to disturbances to the court proceedings and due to security reasons. Poor infrastructure in trial courts. The infrastructure in trial courts, especially in the rural areas, are very poor in India. In some courts, there were no chairs, no even chairs for the advocates. Even in these circumstances, it's possible to implement computerization and positively get the benefit out of the information and communication technology in justice administrative system. A few suggestions. Use of laptops in the courts by the advocates may be permitted to save the time of the courts as well as the lawyers. The government can take initiative to provide Wi-Fi facility in all court complexes free of charge as they are implementing in business hotspots. Compulsory video conferencing will reduce the need for transportation of under trials from prison to court and vice versa, and save money, manpower, time, and thereby assist speedy justice. Conclusion. Ignorance of law is not an excuse. Time has elapsed to implement the technological change in courts to furtherance the access to justice. Justice delivery system has the tremendous possibility to be benefited by the technological revolution. The response of the judiciary towards the information and communication technology is positive and technology friendly. Though in its initial stage, e-justice system has sprouted in India, this will miraculously change the future of the litigation system in the near future. Thank you very much.
Thank you, Mr. Judge. Now will speak Mr. Srish Agrawal, the young and energetic advocate, General Secretary All India Bar Association, to speak about the matter. subject.
Thank you, sir. Good afternoon to all distinguished participants. I am Shirish Agarwal, General Secretary of All India Bar Association and Editor-in-Chief of India Legal Information Institute, which is an institute which provides free legal information to all free of charge. I bring to you all to this function connected with the computerization of law and courts, the greetings of the Indian Bar. I feel privileged to participate in this conference and thank you all for the enrichment provided through the experience of diverse legal cultures being represented in this august gathering. Law is considered to be the bedrock of civilization, holding societies together. It must become a tool for social change, and for that purpose, it must constantly evolve to serve the growing society. This law is brought into action before the courts that assigned the task of interpretation and enforcement. These remedial fora are responsible for infusing life in the otherwise dead letter of the law. The focus of our discussion would be the functioning of these institutions and how they have been affected by the developments in the area of information technology. The distinguished speakers have already put into perspective the various applications and issues connected with the use of technology. They have emphasized the need for updating of the traditional legal mechanisms to bring them abreast with the strides of technology and thereby making them more litigant-friendly and cost-effective. As Mr. Giri pointed out very aptly and correctly, that even the legal information which is available is not accessible by all. We have another round of discussions throwing light upon the issues to which this technology is being put in diverse legal arena or cultures. Timothy Wu, an eminent scholar and clerk to Justice Stephen of the US Supreme Court, once wrote, "A singular model of internet usage has become too small to capture the dynamic diversity of today's internet. The internet is only the genus, the applications are the species, which can do very dramatically. It does no emphasis, reiteration, that the internet is expanding at an extraordinary rate. It has created a forum in which everybody can instantaneously disseminate their comments worldwide with only a few keynotes and at little or no cost. As computer software and networks become more sophisticated and pervasive, there is a rapid development of online communities and institutions, promising what is called a true-to-life mirror image trapped inside a computer. The march of technology has transformed us from a world of calculation to a world of simulation. Given the development and increasing familiarity of the internet and the World Wide Web, the law has leaped to remain abreast and to respond to the challenges thrown open. In turn, the legal profession has gained immensely from the technological advancements. Research and preparation of cases, methodology of legal study, availability of case law, and documentation are some of the multifarious dimensions that have undergone a complete revolution. However, a pertinent question is, by how many is this information accessible? There are online softwares like LexisNexis, Westlaw, which are very expensive, are not accessible for the beginners, the people who have just started in the legal profession. However, on the other hand, we also have some websites where legal information is available free of cost, like the World Legal Information Institute, of which we are a part. I am representing India Legal Information Institute, which is a website which has all the case laws, statutes, and other legal material which is available free of charge. One reason why creative and commercial activities are moving to cyberspace is that constraints of the physical world are less operative there. At an extreme, virtual worlds can be created which can all enter and participate in no matter where we are or who we are. There is, for example,